Hi, I'm Andrew Meinzer of Meinzer Law Firm PC. In our prior video series, we discussed how a California trust gets under court supervision. In this video series, we'll focus on how that impacts carrying out the trust provisions, in other words, trust administration, in California. This is the first video in a 2-video series. Additional requirements and restrictions apply to trusts that are under court supervision. They are: 1. The trust must be irrevocable. 2. The trustee, who is the person in charge, can invest in only certain types of investments. 3. The trustee must file a surety bond with the court. 4. The trustee must file periodic account petitions with the court for approval. 5. Only the court can appoint a successor trustee of the trust. 6. The trustee cannot sell trust real estate without obtaining prior court approval. And 7. The court must approve the trustee's fees and his attorney's fees prior to the trustee paying these fees from the trust estate assets. I'll try to flesh these points out a bit for you. First, the trust must be irrevocable. This means that nobody can terminate the trust or modify any of the trust terms without obtaining a prior court order to that effect. Second, the trustee can invest in only certain types of government bonds, other government obligations, and stocks and bonds listed on a public exchange in the United States, among a few other things. Third, the trustee must file a surety bond with the court. A surety bond, also often referred to simply as a bond, is like an insurance policy. If the trustee mismanages the assets, absconds with them, etc., then the company that issued the bond may be responsible to pay into the trust estate to replace the lost value. For additional information about bonds, please see our prior videos on that subject. Fourth, the trustee must file periodic account petitions with the court for approval. Like conservators of conservatorships of the estate, the trustee must file an account petition for court approval after the first year. Then he needs to file an account petition every other year for the duration of the trust administration. Among other things, an account petition discloses: 1. All assets and their values at the beginning of the account time period. 2. All assets and their values at the end of the account time period. 3. Each receipt or inflow that occurred between those two dates. And 4. Each disbursement or outflow that occurred between those two dates. For more information about filing account petitions for court approval, see our prior videos regarding conservatorships. The process is the same with conservatorships of the estate and trusts subject to court supervision. That's enough for one video. In the next video, I'll flesh out the 5th, 6th, and 7th additional requirements and restrictions that apply to trusts under court supervision. See you there. Hiring an attorney experienced with trusts can help avoid a lot of this. In addition, the advice and guidance of an attorney experienced with trust court cases is invaluable for attaining your goals in these types of cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients achieve their goals in trust cases. Again, I'm Andrew Meinzer of Meinzer Law Firm PC. If you know that you need our help, or even if you just have a question, please contact us and let us take care of you.